So this one goes as follows. We have a tenant. So this one comes from an agent. They have a tenant that wants to provide her 20 business days notice and is also accepting responsibility for the cancellation penalty. However, the tenant does not want to be held liable for the 3-month period should we not place a new tenant due to the nature of her being forced to cancel the lease. Her being forced is because she states that there is an unwanted and destructive spiritual presence in the home, which is causing extreme discomfort and fear for the tenant. The landlord is, of course, now in denial of this presence, of this destructive spiritual presence, and hasn't assisted in any way to have it removed. So the tenant is claiming it's not their fault, nothing has been done despite it being reported. The question then, can we still enforce the rental bills in this case should the house not be rented out timelessly? Also, this being said, this is a he said, she said situation. So, will this have to be disclosed to the new potential tenants? And I suppose that is referring to the spirits that are being destructive. Nick, you might have to break that down into a couple of sections,
Yeah.
but yeah.
Perfect. Okay, so let's just deal with the starting point of this is there's been a 20 business days notice to cancel the agreement. And it said that the tenant accepts the cancellation penalty. So this obviously refers to our Section 14 of the Consumer Protection Act. Section 14 provides that a consumer of a service is entitled to cancel a fixed term agreement with a 20 business day notice to the supplier of that particular service, and that includes lease agreements within our society. Okay, so the consumer, the tenant in the circumstances, is entitled to give a 20 business day notice to cancel the agreement. Now, what is important about that 20 business day notice is it is not a cancellation of an agreement where a breach is necessary, okay, as is formally, most contracts within our society, they function, and the cancellation occurs if there's a breach, some party is not performing in terms of the contract as they should be. That is not the case. The Consumer Protection Act provides this out for a consumer of a particular service, just as a means of protection for them. Okay, so there doesn't have to be a reason, okay, for this cancellation. The tenant can do it at any point, and whether they just want to get out of the contract or they believe that something is happening on the premises that they don't like, that doesn't matter. They have this right. The kicker to that right is that they can be liable for a reasonable cancellation penalty. We're told that the tenant accepts the reasonable cancellation penalty in the circumstances, and the landlord can enforce that. Okay, what that reasonable cancellation penalty is depends on the facts of the particular case, okay, and the circumstances of the particular case. Where I want to be careful about this particular question is, I'm not sure if this is a provision that's written into the lease agreement about continue to pay rental. But rental is something very specific within our law that is remuneration for the use and enjoyment of someone else's property. Okay, that is all rental is. And if a lease agreement comes to an end, okay, so it's cancelled, you are no longer entitled rental from the cancellation of that agreement, okay, because you're not entitled to the use and enjoyment of the premises once the lease agreement comes to an end, okay. So I've got a little bit of question about how the question was actually phrased, okay, so you wouldn't be entitled rental from the point of cancellation. So I'm not sure if this is a hang up from the particular wording of this lease agreement. You would then at that point be liable for the cancellation penalty. And that is all you'd be entitled to. You can't have a situation where you're getting rental after the cancellation of the lease agreement, plus also you get a cancellation penalty on top of it. Even if your lease agreement said that, that's going to fly in the face of legislation. So that might be a problem. So just to the question there, I would need a bit more clarity on that circumstance, but it doesn't seem like your first question was, can you continue to enforce the rental? No, not if the tenant has given a cancellation, and the reason for that cancellation is irrespective of what they say. And then to your second question, do you have to disclose this to any incoming tenants on the particular property, no. There's no positive obligation on landlords really to disclose anything with regards to the property, apart from the fact that the Rental Housing Act does have some entry inspection requirements which you must comply with when you are taking a tenant into the property. But no, there's no need to disclose something like this to any incoming tenant in the future.
So Nick, on that point, I actually remember at a stage we did a video. I think Silna and I did a video like this. I think in that instance there was a death on the property, some time back.
Yes.
So there was also again like a spiritual issue where this person had found out that there was a death, and so obviously their complaint to the landlord was that they should have been told about this, or that any crime was committed on the property, even if it wasn't a death. So obviously it's always a difficult one because materiality really depends on the individual. So for some people it'll be like, oh well, you know, it doesn't impact me, so does it really matter? And obviously for other people it's more material. But what we have found in practice, and this goes to exactly what Nick was saying, is these in practice, it's the condition of the property that's really catered for in our law, not these type of disclosures. I'm not saying that it's right or wrong. This isn't any sort of commentary on the way things are approached, but the main focus is the property habitable? Is it in a good condition? And in those circumstances, it's normally accepted that anyone that moves into the property would have the use and enjoyment of the property the way that they intended. So that just goes back to what you were saying, is this question comes up a lot more than one thinks. The landlord does have an obligation to disclose the condition of the property, no question. But things like this, it's not a must.
Yeah.
Right. So thank you very much, then, Nick, and obviously thank you to yourself as well, Bruno, for chipping in. And then